This is your daily dose of all things royal. Welcome back, my gorgeous, good-looking friends. So, Judge Carl J. Nicholas has issued on September 23rd, 2024, his memorandum and opinion regarding Harry's visa case. Now, here is a great example of how Harry's media, or PR, is in overdrive to spin a narrative that Harry is entitled to his privacy, and the judge rules that Heritage Foundation cannot see this information about his visa, despite Harry's drug revelations from the book Spare. It's interesting that the Washington Post was one of the first to report on this story, not People magazine or the preferred outlets that Meghan and Harry normally use. But in any case, the Washington Post reports saying that the U.S. judge denied a petition by the Heritage Foundation to release Prince Harry's immigration records, ruling that the British royal's right to privacy outweighs the public interest arguments cited by the conservative think tank. Now, when you look at all these articles that are now being flooded in the media, this is the narrative that they're going with. Now, my gorgeous, good-looking friends, those that have been with me have been on this journey in the, I want to say, enlightenment of how the media really operates and looking behind the curtain as to these PR firms who are pushing propaganda on behalf of their clients. And I believe, this is a fact, in going through the actual court documents today of what the judge said, there is definitely a narrative that they are pushing everybody on in order to focus on this part, but not that part. And what we're seeing here with this situation is that they're making it sound like Harry's privacy needs to be protected, not only because who he is, but the public, us peasants, don't deserve to know. And because he's a foreign national, we need to protect him at all costs. Let's get into the real of what is happening here, because nobody is reporting this. And in fact, when we look at Niall Gardner, this is his response to this judge's decision. Statements on the Prince Harry U.S. Immigration Records federal court case ruling. From my colleague, Mike Howell, executive director of the Heritage Oversight Project, the Prince Harry scandal just got a lot more suspicious. While our case is far from over as we explore appeal, I'd say that these very curious redactions point to something serious afoot. President Trump has already suggested that Prince Harry will be deported next year, and the case for that just got a lot more compelling. Americans deserve an immigration system with both secure borders and also fairly applied rules for high-profile immigrants like Harry. It certainly appears that Harry was given special treatment, and now we know it was for something so serious that it involves extensive redactions. Americans will know the full story soon enough. First, let's go ahead and clear up a misunderstanding that Niall Gardner seems to have. So he's saying that President Trump has already suggested that Prince Harry will be deported next year. No, he never suggested that, but instead stated verbatim, if he lied, they'll have to take appropriate action, meaning the rules are going to have to apply to Prince Harry. The other thing that's stated here are the curious redactions that were in this document once it was released. And we're going to look at that to see if indeed they're very curious or signifying something else. In my humble opinion, I think the Heritage Foundation went about this all wrong. They use the border crisis as well as the broken immigration system in order to go ahead and try to get information about whether or not Harry was given special treatment as a member of the elite. I think now in this appeal, the Heritage Foundation needs to look at the bigger picture and scope as to why this man came over in 2020, like the real story, and understand that the public interest does outweigh Harry's privacy when it comes to attacking our Constitution. And this is what I've been saying from day one is the most important, and it does outweigh his privacy interests, especially if he was here undermining the First Amendment by participating in this censorship industrial complex. When you have a foreign national who is an unregistered foreign agent attacking the Constitution, that is considered a domestic terror threat. Now, when you look at it from that angle, that absolutely outweighs Harry's stupid privacy in favor of public interests. Anyhow, let's take a look at the unsealed memorandum opinion that was posted on September 23rd, 2024. In it, it says, in this Freedom of Information Act case, plaintiffs seek the disclosure by the Department of Homeland Security of certain immigration records relating to the Duke of Sussex, a member of the British royal family known popularly as Prince Harry. The government argues that the Duke has a privacy interest that outweighs any public interest in those records and has therefore withheld them, and with respect to one category, has declined to confirm whether they exist at all. Following an in-camera review of certain records and associated declarations, the court agrees that the Duke's privacy interest outweighs any public interest and therefore grants defendants' motion for summary judgment, ECF number 23, and denies plaintiffs' cross-motion for summary judgment, ECF number 26. So now here's what I find really interesting. When they go through the background of Prince Harry's name, they write, the Duke of Sussex's full name and title is His Royal Highness Prince Henry, Charles Albert David George of Wales, the Duke of Sussex, the Earl of Dumbarton, and Baron Kilkeel, KCVO. Now, the fact that in this American document he is being listed as His Royal Highness means that the American government sees Harry as HRH. Doesn't matter if the Queen and King Charles say that they put his titles in abeyance. The United States recognizes him as a foreign dignitary. So say what you want. I mean, this is our issue and our fault that we're entertaining this fool, but we are. Hence the reason why the American taxpayers are paying for his security. Now, King Charles could very well put his foot down and tell the United States, Prince Harry doesn't represent the crown anymore. He is now a private citizen. He is still a part of my family, but he is not a working royal and does not represent the UK when he is overseas, period. And that would put a stop to it, but he hasn't. So it makes you wonder, why not? So now, to give a quick summary as to how this lawsuit kicked off, it all started when Harry released his book, Spare, back in January 2023, of which, in the book, he admits to doing illegal substances like cocaine, like psychedelics, doing marijuana. And part of the immigration process and the form to be filled out is having to admit or confess to drug use. So now after hearing that, that prompted the Heritage Foundation to question, did Harry get preferential treatment because of who he is? Regular folk like you and I, if we were to admit drug use, we'd either be denied or have to seek a waiver. Then that was the other question that popped up. If Harry then went the route of seeking a waiver, if he did tell the truth on his application, how did he get this waiver so quickly? Because when he came to the United States, it literally was in such a short window of time. They didn't know that, or according to Harry and Meghan, they didn't know that they were going to be moving to the United States. Now, I have shared that I don't believe the story that this couple fed to the public on the timelines when they were coming over here. That, in my opinion, most likely is a big fat lie. But the court is taking what Harry said, not only from his book, but what's been documented in the media as the truth and gospel as to when he came over here and is adhering to that timeline. So they were raising the red flag that, one, did he lie? If not, then how did he get a waiver so quickly? And then the third possibility is he here in the United States bypassing the whole application process because he's on this diplomatic visa? And that's kind of where this was left off with the judge to see what's really going on. Hence the reason why he requested certain information and documentation to then go ahead and make this opinion. So as it says here, the court ordered the government, DHS, to provide it declarations detailing with particularity the records it was withholding and the particular harm that would arise from public disclosure of them. In response, the government turned around and gave 3 declarations from FOIA officers at the Department of CBP and USCIS, and those were already presented in this court case. Those declarations describe the records that each entity had located in response to Heritage request and provide further information regarding the basis for the government's arguments for withholding or for not confirming or denying their existence. And here's where you get all these redactions. So, just so people can understand, going back to August 2023, in document number 23 1, it says here that USCIS had reviewed these documents and determined that all the responsive records are categorically exempt from disclosure pursuant to FOIA Exemption 6 and in part based on Exemption 7C and 7E. Then later down below, it says CBP located person encounter lists and person encounter detail records regarding Prince Harry within the tech system, but he is withholding them pursuant to exemptions 6, 7C, and 7E. So now, prior to this opinion, I fully didn't make the connection about these FOIA exemptions. So apparently at DHS, as well as other departments like Department of Justice, there are 9 exemptions that they can pick from to deny giving information for. In this case, CBP and USCIS all have been putting down that this case is exempt based off of exemption number 6 and then also based off of exemption number 7C as well as 7E. Protects information that would constitute a clearly unwarranted invasion of personal privacy of the individuals involved. Example of information the Department of Homeland Security may withhold using Exemption 6: Social Security numbers, home addresses, and telephone numbers, certain identifying information regarding department employees. Exemption number 7 covers protecting records or information compiled for law enforcement purposes, the release of which could reasonably be expected. And within this category, there are 6 subcategories in which 7C and 7E are being used for exemptions here in this court case. 7C says, to constitute an unwarranted invasion of the personal privacy of a third parties, in some instance by revealing an investigative interest in them. And then 7E says, would disclose techniques and procedures for law enforcement investigations or prosecutions. Now, keep that in mind as we go back to the judge's opinion. So as it says here in this opinion, under Exemption 7, the government can also decline to release certain records compiled for law enforcement purposes. These are generally records for which there is 1. A rational nexus between the record and the agency's law enforcement duties, and 2. A connection between the subject of the record and a possible security risk or violation of federal law. So now under this Exemption 7C subcategory, government withholdings under Exemption 7C are subject to a 2-part test. First, the records must be compiled for a law enforcement purpose, which can be determined based on a focus on how and under what circumstances the requested files were compiled, and whether the files sought relate to anything that can fairly be characterized as an enforcement proceeding. Second, the government must show that 1. The disclosure of the records would reasonably be expected to constitute an unwarranted invasion of personal privacy, and 2. That personal privacy interest is not outweighed by the public interest in disclosure of the records. Exemption 7E under Exemption 7 says, in turn, permits the government to withhold records or information compiled for law enforcement purposes, but only to the extent that the production of such law enforcement records or information would disclose techniques and procedures for law enforcement investigations or prosecutions, or would disclose guidelines for law enforcement investigations or prosecutions if such disclosure could reasonably be expected to risk circumvention of the law. But even when an exemption applies, the court's inquiry does not stop there. FOIA requires the release of any reasonably segregable portion of a record that is not exempt after appropriate redactions have been applied. However, the government can withhold an entire document if the non-exempt portions are inextricably intertwined with exempt portions. In those cases, the government must provide a detailed justification and not just conclusory statements to demonstrate that it has released all reasonably segregable information. The burden is on the government to show with reasonable specificity why a document cannot be further segregated. So as they refer to this court case, Preservation Fund, Inc. versus HUD, it says Exemption 7C requires only that the agency establish that the privacy interest protected by the exemption is an interest in avoiding disclosure of personal matters and keeping personal facts away from the public eye. And as it says here, in particular, the summary judgment record reflects that the Duke has never disclosed publicly, among other things, the following facts, and this is all redacted. That is the type of information that a person would ordinarily not wish to make known about himself, and therefore the government has demonstrated that the Duke retains a privacy interest in these records. So in part 2, the judge is actually telling us, without having to spell it out, and saying whatever interest the public has in disclosure of the records is outweighed by the Duke's privacy interests. It says that does not end the matter, of course. Under Exemption 6 and 7C, the Duke's privacy interests must be weighed against the public's interest in disclosure. Heritage's principal argument is that the public has an interest in knowing whether DHS committed misconduct or acted negligently in either admitting the Duke of Sussex or in allowing him to stay within the United States. So knowing what we know about exemption number 7 and it pertaining to law enforcement purposes, looking at 7C and 7E, this indicates to me that there is an open investigation on this guy, and rightfully so. They are protecting his privacy because whatever is in there that's being investigated could potentially stigmatize or embarrass him, which would fall under the guidance of this law. You know, when you look at these 6 subcategories, why didn't they choose 7F, where it says to endanger the life or physical safety of an individual? We should expect that there is something more going on here because they already had exemption number 6. That would have been enough, but adding exemption number 7, dealing with law enforcement.
Girlfriend, things that make you go.
Like when you think about this, all Harry does is scream about security. I hope people are starting to understand that the reason why Harry keeps crying and going on about this IPP status for he and his bitch wife is because not only do they want access to intelligence, but also for the immunity. And if this guy is under investigation, which it does seem like he is, according to this document and the exemptions that are being put in place and being accepted, then yeah, I was not really putting 2 and 2 together last year when this case was going on because we were so distracted around the book Spare, his drug use, as well as the deflection left and right. But these documents had been telling us this the entire time. One of the declarations that was mentioned in this opinion, dated July 5th, 2023, it says here, it states both Exemption 6 and Exemption 7C have been found to protect the privacy interests of all persons mentioned in law enforcement records, including investigators, suspects, witnesses, and informants. Courts have long recognized the mention of an individual's name in a law enforcement file will engender comment and speculation and carries a stigmatizing connotation. Not only the targets of law enforcement investigations, but also witnesses, informants, and investigating agents have a substantial interest in ensuring that their relationship to the investigations remains secret. We therefore find the privacy interests of both the Duke and the CBP officers mentioned in the records to be significant. Now, before everyone jumps to the conclusion about Harry being investigated for SA, please do not jump to that conclusion. The example that was used in the transcript did not come from DHS. This example came from the Heritage Foundation, who would have no idea that Harry would be investigated for something like that. Heritage Foundation just used it as an example because there were a lot of similarities from a legal perspective and immigration perspective. It has nothing to do with looking at whatever the crime was from this person back in Ireland. Now, I wouldn't rule out SA. I would just add it to the long list of things that could be investigated by the FBI on this guy, as well as his wife.
Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys.
You know, when I look at Harry and all the things that he has been involved with over the last 4 years, you would think that he was Hunter Biden's replacement. The people and the things that these two have been involved with are completely corrupted to the core. Now, it's my opinion, but I believe that Harry is getting very nervous because things are now starting to catch up with him as more things are coming to light, like exposing his wife for being a complete fraud from the very beginning, and then looking into all the dirty things that these two have been involved in over the last 4 years and are behind. So it's going to be interesting to see now the propaganda being spun about Harry's marriage and how it's not working out. And he's running back home because he misses his family and friends so much and has realized that he made a mistake. Or I don't think he'll ever admit that he made a mistake, but he's certainly going to run back home in the protection of daddy's arms. You can bet that, especially if there is an investigation going on in him, which after reading this thoroughly through makes me believe that something is definitely going on. But that's all just my opinion. You don't have to take it for anything. You're free to do your own research and interpret it however you want. This is just my perspective and take on what I see. But what do you guys think? Definitely leave your thoughts below. As always, I will be back with more content. But until then, please be safe and I'll talk to you later. Bye!
I was such a fraud.